Welcome, everyone. Thank you for coming to BEUC's panel on enforcement redress for consumers under the AI Act. My name is Marian Fernandez. I'm head of digital policy at the European Consumer Organization, and I have the pleasure to share the stage with wonderful speakers. So we have Marieke from the Dutch Ministry of Economic Affairs. He's a team leader there in charge of digital markets and services. Then we have Peter Roth, Professor of Civil, Commercial and Information Law at the University of Oldenburg. We also have Mika from VCBV, the Federation of German Consumer Organizations. And online we have another colleague, Jan from Business Europe. He's an internal market advisor there. So thank you for joining us. It's hot time for AI, especially the AI Act. Just yesterday, the Council member states approved the text. It's funny when you look at press releases and the press, because it seems that the AI Act was adopted many times. But if you follow the EU policy making, you would know that yesterday was a key momentum, because now the next step is for the publication of the law in the official journal, and then we'll see how it's going to be rolled out. So here today we're going to talk about compliance of the AI Act on the first instance, and also what happens if something goes wrong. So how can we already foresee and plan ahead about what's going to happen with the AI Act to really protect consumers, so people like you and me and our esteemed panelists. So I would like to start with Marieke, if that's okay. I hope that's okay with you too. Basically, Marieke, you of course don't work for an authority, but work for the government. And I know already that you guys are planning already. Even in the break, you told me that you're going ahead even in comparison to other member states. So yeah, can you tell us a bit what you're doing in preparation for the AI Act? How can it be implemented correctly, and what is being done particularly to ensure that it works for consumers? Thank you.
Okay, thank you, Marianne. Thank you for the invitation. Well, I'm going to share with you a little bit of the process in the Netherlands about how we are going to implement the AI Act. Now it's there. So we have started several activities which in our view are needed to implement the Act. So we are preparing the legal process, discussing the oversight structure with the relevant authorities, and organizing the interministerial governance to enable proper decision making. A little bit more in detail. Of course, what we need to do is start writing the national law. That sounds simple, but it's not. But so we're working on that with a lot of other ministries. And we have to check what is needed in national law to implement the Act fully and efficiently. And that's where we are now. And we're doing that not only for our ministry, the Ministry of Economic Affairs, but we're doing it together with others, mainly the Ministry for Justice and for Internal Affairs. But as the scope of the AI Act is very broad, all other ministries are involved one way or the other. So we have an internal set of working groups to discuss the AI Act and what we're going to do. But we already had discussions with all of them during the negotiations in the Council working group, so nothing's new there. Second, what we are looking at, we think, well, we need to have a communication plan. The AI Act is only going to work if you inform people, mainly at first businesses. What will be your obligations under the AI Act, to see if we can help them anywhere. I think that's the first thing we have to do. And then we are preparing a communication plan, a national communication plan, which has several topics. First, we have some kind of general communication. So what is AI? What can it do for you? Also, where can I file a complaint? And so on. And we have specific communication that's sectoral. Because in each sector, I think there will be something different. And there we need ministries that are responsible for those sectors. So that's the second thing we're doing. And third, we just started with some pilots on the sandbox, the regulatory sandbox that's obligatory for the AI Act. So we want to try them out already to see how it works, if it works, what stakeholders need, and so we can adjust them before the AI Act will be implemented. Then fourth, in the AI Act, we need to set some standards. And we want to give the inputs for them to the Commission, so we are also preparing for putting up standards. And I think there's where consumer organizations come into play, because specifically in the AI Act is mentioned that they should also be consulted for those standards. And last, we are waiting for implementing and other acts from the Commission to form the AI Act further, but so far as I know, there's nothing yet. And the first meeting of the AI board will be there, I think, in June, so that's also something we will participate in. So that is for me right now.
Very interesting. So you seem to have a lot, like, of course, procedurally speaking, you seem to have working groups, comms plan.
Yeah,
some
and I forgot enforcement.
Yes?
I will come back to that later on your second question, because that's something that's
perfect.
Needed.
So it seems that the government is quite busy organizing how to comply with the AI Act, including on comms plans, also regulatory sandboxes, with some pilots, also to see what stakeholders will need. It would be interesting to hear from Jan later on what Business Europe has gathered stakeholders that are gathered in the association would need. But before I do that, Peter, procedural matters will be crucial. Right, so if an enforcer or a claimant need to prove that an AI system is not compliant with the AI Act or is unsafe or defective, this can be challenging. And to what extent does the obligations under the AI Act will affect the burden of proof? And would another piece of legislation that is not very talked about that much, which is the AI Liability Directive that is in the works, will that draft AI Liability Directive make an important difference in this topic?
Well, let me first start by saying I'm a civil lawyer, so we come in when things have gone wrong. So when public law has failed to prevent like unsafe AI to come on the market in the first place. The AI burden of proof is one thing, but what you first need is a claim to start with, so a basis for liability. Now, the AI Act doesn't provide for that because it's a purely public law framework. It doesn't deal with liability at all. So we need to find it elsewhere. We can find it in product liability law as far as we are talking about AI that is embedded in products, that is products. Here we hopefully, with the adoption of the new product liability directive, will get some solid rules on burden of proof. In particular, a duty to disclose evidence that is available to the producer. Now here, in that sense, the AI Act will help indirectly because it forces the producers to have all that evidence at their disposal because they have to draw up technical documentation and God knows what to satisfy the public law duties under the AI Act, which is primarily to show to the authorities, but which can also be used in that sense then. But then the product liability only covers parts of the risky AI systems because it only deals with physical damage and damage to health and life. It does not deal in particular with like financial damage, pecuniary damage. So when it comes to financial services, the product liability directive doesn't help at all. So we need to look elsewhere. And that elsewhere isn't present yet. So with that elsewhere, we're back to the national law, and we need to find liability. And as we know from other areas of particularly product safety law, the Court of Justice has never established that there must be liability at the national level only because there is a public law system, if you remember the breast implants cases. So that depends on the national law, and it's far from clear. The AI Act could help in the sense that we have many legal systems where breach of a statutory duty could lead to tort liability. That's being discussed in Germany, but there are also voices that say, well, that the AI Act wouldn't have that effect. I could imagine that they are industry-friendly voices. So that's not clear yet. The future AI liability directive is a strange thing because what it does not do is it does not provide for liability in the first place. It only deals with evidence and with burden of proof, but not with the liability as such. So the question is, it seems to presuppose it, because why would you have burden of proof without the liability before it? But it doesn't say so. So it still seems that it might also only apply where there is a basis for liability at the national level already, which we don't have necessarily, depending on the national legal system. So in that sense, it's sadly deficient to start with. The rules it brings are also a bit weak, much weaker than the Product Liability Directive anyway, because first of all, the disclosure of evidence is only provided for high-risk AI systems. That seems to make sense because the technical documentation must be ready. Well, why not having it otherwise? So for not so high-risk AI. And then it also contains a presumption of a causal link between the breach of duty and the output, but only once the fault has already been proven by the claimant. And then also it ends with the output, so for example, bad financial advice, but then you still need a causal link between that bad financial advice and the damage done. And that, again, is not dealt with. So it is, in particular, compared with the Product Liability Directive, from a civil law perspective, pretty weak. Thank you.
Wow, this is a very interesting negative picture just the day after the member states have validated the AI Act. So if I understand correctly, there's still some loopholes. The good news is that the AI Liability Directive is not concluded yet. So, if you're a policymaker in the room or you're listening online later on, just hear this piece of advice. The work is not there yet. But I guess this could be maybe beneficial for some businesses in the sense that, maybe to prove that you're not compliant with the AI Act will be more difficult for anybody who wanted to make a claim, if I understand Professor Peter Roth correctly. So, Jan, how are companies preparing to comply with the AI Act? What do you see as the most important tools that companies need to ensure that the AI Act will be a success to protect consumers as it was intended? Marike mentioned before regulatory sandboxes. Is that something that the companies that you represent or the interest would welcome? Can you tell us a bit more?
Yeah, so thanks again for the invitation here. For those that don't know, so Business Europe, very quickly, we're the recognized social partner to the EU institutions, representing the businesses of all sizes, and our direct membership comes from the national business federations from 36 European countries. So I think with that quickly out of the way, getting right to your question, what are companies doing? I think very evidently maybe there isn't actually a blanket answer. So what works for some in terms of preparation isn't going to necessarily work for others, and that's going to depend on the scale, of course, of the operation. But there are a few commonalities that I find that are currently happening, and I don't think this will come as a very surprising thing for many. So first of all, everyone, I would say, is bringing together their people internally to talk and map out, first of all, what systems they're using. There's a lot of internal discussions, I would say, in the companies going on right now over internal classifications of risk, as much that is possible. What are the data governance policies? A lot of cross-checking across departments, if you're lucky enough to be scaled up to have those, or checking again with legal. So a lot of, I would say, internal administration, just sort of mapping and planning and preparation that's going on. A good amount as well of companies that have been following the AI Act, I would say, are also looking at the standardization process. So that's maybe something that maybe we can talk about in a little bit as well. Going on at Senelec and ISO, IEC level, so internationally. That work has been going on, of course, for a few years now, but that is something that companies that are really wanting to be at the forefront of AI Act, I would say, preparation have been looking at. Then I would say one of the big ones here is that also at the end of the day, right now a lot of companies are just doing mapping and preparation. because everyone, I think consumers as well, are really looking towards the Commission and the AI office for the what's next, right? A lot of these coordinated preparations and plannings and mappings will only really be able to be moved on when there's legal certainty. And as you know, and as you mentioned, we don't even have the AI Act published in the OJ yet. So what we're worried about, I would say, most right now is the implementation and legal certainty that we're going to be facing. Because on paper, of course, we do have a harmonized legal framework now with the AI Act, but in practice, I think it was hinted at already, there are going to be a lot of areas where the member states are going to have transposition and national sort of law coming into play. So we're seeing potentially a really big risk of member states, even though we have a regulation at EU level, taking slightly different interpretations. I think one of the really good examples of that is going to be just in who's going to be the national competent authorities. You're going to have a really potential mix from telecommunications regulators, market surveillance authorities, data protection authorities, all vying to sort of lead on this. And of course, each of those organizations at a member state level has their own sort of philosophy, institutional way of looking at problems. I think a good example here is the Dutch DPA recently put out guidelines on data scraping. So if we would take the Dutch case, would other member state authorities agree with those guidelines? So how would that be harmonized across member state level? If that view of the Dutch DPA was taken on board, what are the implications for that? So these are some of the areas we see as potentially being really, really risky in terms of single market harmonization, I would say. At the Commission level, we're also seeing a big risk, I think, of especially the early stages of the AI office being sort of swamped with all of the requirements to create guidelines and implementing and delegated acts, that they're going to be too busy at the moment sort of just trying to produce these acts and not really focusing on how the state of the art is developing. So they're not going to be able to proactively be looking at how the technology is developing, and they're going to be too stuck on just trying to produce sort of the secondary legislation aspect. So I think in a nutshell, what I'm getting to is that the biggest challenge in companies' preparation is that we want to have the law as clear and workable as possible. And we need that secondary legislation to really help us there. Companies, I would say, are in general very eager for the AI Act, but there is a lot of anxiety that I'm picking up. The other fact will be costs, of course. So there were assumptions that were made with the AI Act that the Commission sort of presented at the time. These will, I think, need to be looked at and sort of reevaluated and see if those are still accurate. I mean, for example, when the support studies were coming out to the AI Act, if you sort of calculate it out for high risk cost, compliance cost comes out to around 30% of your AI development cost. So these are things that need to be taken into account as well, of course. So I hope that sort of at least answers the sort of first questions. Companies are looking forward to the AI Act, of course, but I mean, we still need a lot more, I think, legal certainty from the Commission in terms of the guidelines implementing, especially the high risk requirements. So I'll leave it there.
Thank you very much, Jan. I mean, it seems that indeed, of course, it's still early stages, but it looks like companies are looking at it, but lots of admin ahead, and of course, looking at what the different authorities in the European Commission are going to do going forward. You said that maybe the Commission is not going to look at how the technology is developing. I am sure that civil society, like VCVV, is going to look at what companies are doing, or so we hope. So, Mika, what can civil society organizations like VCVV or other BEUC members can do to make the most of the AI Act to really make a difference and address some of the harms that we already see now?
Yeah, thank you. Yeah, we're certainly looking how this is going to play out, but the question is what you can do. For many, it may seem a bit weird because the council has performed, the EP's show is over, but the show is still going on because we already heard about the guidelines that the Commission has to draw up until end of 2025. For example, about transparency obligations, the prohibited practices. So, for example, make concrete lists what is going to be prohibited now, because the prohibitions, they are pretty. Yeah, I would say they contain some loopholes, but also definition of AI systems, and then there are delegated acts. And these are formats where the civil society organizations can probably approach the Commission and also provide information and still have an influence on the final, well, on the final written the written basis that we will all operate with in 2 years. The same thing goes for standards. The standardization organizations were already mentioned. This happens on a national level, but also on the European level. So there is always room for involvement. And I know in standardization, the civil society is chronically underrepresented. This has some reasons, but civil society organizations should, if they could, approach this and participate. Then the second part, where you still have room of influence as a civil society organization, is the national implementation of the AI Act. For example, remote biometric identification. The AI Act prohibits remote biometric identification for state actors with certain exemptions. What they left to the member states is remote biometric identification in public places by private actors. So, for example, when you walk into a shopping mall and there's a camera hanging at the ceiling, this will not be covered by the AI Act if it's run by, for example, the shopping center. And the AI Act specifically does not cover or specifically does not touch the GDPR and member states. The GDPR says that member states can use the GDPR to go further with remote biometric identification than the GDPR already does. So there is a possibility to ban it for private actors if you want to do it as a member state. That's the question. So we are advocating that this should be done for simple reason that consumers are pretty much defenseless against remote biometric identification, and this will exacerbate the problem of video surveillance we already see. Basically, I heard a nice saying from a guy last week. Remote biometric identification powered by AI in the normal cameras we already see today will turn us all into walking QR codes, and I like this metaphor because it pretty much points to the problem. 2 more points on the national implementation of the AI Act, and it leaves quite some room for designing the way the market surveillance system will be built. And what we see is a possibility to get civil society organizations more involved in the market surveillance activities once they are implemented. One way would be to copy the idea of the National Advisory Forum to the national level, so that you have a sort of national advisory board, and the function of this would be similar. So it would be a board with civil society organizations, but also academics and business represented in a proportional, equal manner. And their job would be to advise the market surveillance authorities on the new developments in AI, are there new problems emerging, and but also with the ability to publish recommendations. So sort of putting pressure, being able to put pressure on the market surveillance authorities and to put attention to this field. But also equip them with information rights, which we don't see on the European level, but this could be done in our assessment on the national level. So you had this advisory board, which could get information into for example, on investigations into problematic AI systems. The last point would be specifically a consumer point, or a point for people who are affected by AI systems and who want to use their right to complain, which is enshrined in the AI Act. And the AI Act foresees that there is a market surveillance authority, which is the third single point of contact, so this coordinating authority. And we think that this coordinating market surveillance authority should be the single point of contact if consumers or citizens want to complain about AI systems if they suspect something that they violate the AI Act. And they should be able to approach this central market surveillance authority in each member state. And there should be a process being set up that allows for these complaints to be handled very unbureaucratic, very low-key, so that consumers don't feel inhibited to go to the authority and complain. For example, the complaint process should always be within this one single point of contact authority, so that consumers are not directed to other sectoral authorities, which would probably be very frustrating and discourage them in the end to go through with their claims. So this would be some advice for the first round.
I hope policymakers in the room, including you, Marike, are taking notes. Otherwise, we'll send them over. Clearly, civil society is watching the space, and already, one day after the member states again approved the final text, it seems that we already see loopholes. And there's already, luckily, some recommendations early on being made on how to make the best out of it, so we don't wait, for an evaluation eventually years on to see what could have been done better. And so that brings me to the second set of questions that I have for you. Peter already alluded a bit to it in the sense that we talked about compliance and the preparations towards it. And Peter said, well, what I like is to talk about what happens when things go wrong. And you already alluded a bit to it, and some of the speakers mentioned standardization bodies and some of the work that has been going on already for some time. So how will the reliance on certification bodies and harmonized standards affect the burden of proof again for the AI Act and other related legal instruments that you mentioned before work together, again, for the benefit of consumers? Peter, if you want to come in.
We can, again, take this to the higher level of tort law or liability law in general and what we learned from product safety law in that respect. Well, in principle, it's quite easy. Non-compliance with a standard is usually equated with a breach under tort law. That's the easy part. The more interesting question is what compliance with a standard means. And it is not, under consistent case law, it's not a safe harbor for industry. If they comply with the standard, they may still be liable under tort law. This is pretty much clear under the Product Liability Directive, where there is a defense, but only for mandatory standards, which harmonized standards are not. They are only providing safe harbor, they're not mandatory. And courts have always, civil law courts have always reserved their competence to review a standard as to its adequacy and to see whether there could be a breach of a duty to take reasonable care, etc. That's the theoretical part of it. In practice, courts, of course, often rely on standards and on compliance with standards, unless there is an indication of some kind that either the standard was inadequate or that, say, certification was unreliable. So there have been instances of inadequate standards that were simply outdated at the time when a product was put on the market, and where industry already knew that it was outdated. And there have been cases of unreliable certification. I only need to refer back to the breast implant scandal again. So certification does not mean that everything is fine. But as I said, first of all, you would then need to bring evidence that something went wrong, either in certification or with the standard as such, which again is a bit of a threshold. What is sadly missing in the system is again, and this again we know from the breast implant scandal and the likes, any sort of liability of certification bodies to make sure that they actually do their work and do the work properly. And I mean, they will have a real challenging task in the future to certify not only safety, but also human rights implications and God knows what, which is slightly beyond their expertise as they had it so far. So I'm not too confident that everything will be great only because it's certified. We know that, or we've seen in medical, or say authors have very often written that private total liability of certification bodies would be a necessary incentive for them to do their work properly. And still we don't get it. It's still, it's not in the AI Act in any way. There is something about liability insurance, and you wonder what they could be liable for, but liability is not there. And the same system we have in the medical devices regulation. National case law went all the ways, as we remember the dealing of French and German courts with the certification body of TÜV Rheinland in the breast implants case. And it's not easy to hold them liable. So in that sense, I wonder why EU law hasn't learned any lessons from the last disaster.
Again, Marika, I hope you were taking notes, and other policymakers in the room. Yeah, it seems that it's, yeah, I mean, if I can summarize your intervention, it seems to be that liability is not there. There are a lot of question marks. That even if you're certified, it doesn't mean that you really comply, or it shouldn't mean that. And if I understand correctly, you're asking for more accountability in the ecosystem.
Absolutely.
I would be interested to know what Jan thinks about that. Also because I imagine that some of the members of Business Europe will be involved in standardization. I mean, Jan, you mentioned before that that work has been ongoing for several years. And one of the questions I have for you, if I can turn to you, Jan, is, yeah, what do you think about what Peter said? I think would be interested if you have any reply to this. And also, if some of the companies provide services, sometimes actually the AI system is not developed by them. So what happens if something goes wrong? Are the companies that you represent a bit scared or uncertain about who can be held responsible or accountable? Do companies feel safe under the current system, or do you think that additional safeguards are needed? Like, do you have any more recommendations for policymakers and regulators in the Commission going forward? Thank you.
Yeah, so I think on what Peter said there, I think a lot of, very valid points as well, but there's one, I think in particular where I think, Peter, you mentioned that some of the standards can be outdated that the companies are using. And there can be a few various reasons for that. I think one that we're having a particular problem from industry side is actually when it comes to, and this is getting into the politics of standardization and the procedures under Regulation 1025, the standardization regulation, where you can have backlogs in terms of citation of a standard that's granting presumption of conformity. So basically, in the standardization procedure, you can develop your standard, you can send it off to the Haas consultants and the commission, so the people sort of responsible for checking to see if the standard is compliant, and it can wait. It's not necessarily cited automatically. And that backlog can take years as well. I mean, we have examples. And so obviously, technology isn't static. So the work that was done to grant that presumption of conformity under the standard then is outdated by the time the standard is even cited. So in theory, we could have, especially with AI, cases where everyone worked on it this year. We send it off for citation approval, basically, and it doesn't get cited. We have to wait, say, a year or two, and maybe the technology will change. So by the time the company is relying on that presumption of conformity from that standard, it's outdated. So that's, I think, one of the points to sort of add there. Now, in regards to how are companies feeling with liability and whatnot, I think this gets to the core of the value chain debate and our current liability system, if it can handle AI specifically. As Peter was saying, PLD, and as you were also alluding, PLD, I think, really flew under the radar for many. And this is, I think, a very important file to speak on. And I believe it was rushed in many ways. I think there's a lot of instances there where the PLD isn't necessarily suited maybe for AI itself, and AI potentially should have just been handled under the AI liability directive. I'll sort of give two examples, and I think we can argue, of course, on ECJ case law application, if Crone is applicable here. we can argue development risk defense, but for the purpose of this debate, there's sort of just two questions that I have from the product liability directive revision. The first is that the court can find that the product is defective without establishing actual defectiveness. So when it belongs to the same production series as a product that's already proven to be defective. So first of all, we don't have a definition of a product series. And that can make sense, of course, if we think about like a screw or a physical product. But when we apply that logic to software, and especially for AI, and even more so for general purpose AI, I start to have a few questions that I'd be curious to hear sort of reactions on as well. Because this to me starts opening up this idea, are services or products that are reliant on, say, GPT as a model, are these all part of the same production series? Would it be possible then to just submit a claim targeting the GPT model itself? And would you be able to then trigger sort of a cascade of liability claims for all the products that are really sort of derivative from the model? And I think that would sort of be a very ironic situation, given that would obviously just put the creator of the GPT model at liability, at fault in a way. When we had such a long time in the AI Act debate trying to respect the value chain and ensuring these sort of fair allocation of AI Act requirements. I'm sure you can remember the debate around that. So I think if this sort of view can be taken, that's a bit of an ironic undermining of the entire discussion. I think the second part, and this is, I think, maybe has a bit more merit in considering, is manufacturers should remain liable for defects even after the product is placed on the market or into service, under this new manufacturer's control concept in the product liability directive. And specifically, it talks about like things like updates or machine learning algorithms. And here again, if we start thinking about GPAI and whatnot, if in the AI Act an upstream provider is authorizing or consenting to these updates that are being done to their model by a downstream provider, so this could potentially even be fine-tuning, they're held liable. So does this nullify sort of the value chain responsibility debate again? Because at the end of the day, if things go wrong, it's going to be the manufacturer on the hook under the product liability directive. So again, that's a very specific set, as Peter mentioned, of harms. The other question there is, where's the line, I would say, between a substantial modification, which does transfer liability from the original developer, and this concept of manufacturer's control in these scenarios. So maybe that was quite technical for the audience and whatnot, but I hope that sort of shows that we're, at least from the business side, also wondering how liability is going to look like with AI, to put it mildly.
No, thank you very much. Indeed technical, but I understand, or we understand that, companies are trying to look at, okay, if I receive a complaint, who can I blame for it, if I can summarize, because of course, as a company, you would like to have a fair allocation of responsibility. But of course, from a consumer perspective, if you have a problem, if you have a harm by an AI system, you want redress. Of course, the first question is who to complain to and who's going to deal with your issues. And Mika had some recommendations there for having a coordinating contact point at national level. So that's duly noted. But what else, what other difficulties will consumers face to seek redress? And what do you think, a general person or even civil society organizations representing them can do to get redress under the AI Act and connecting pieces of legislation like the PLD, the Product Liability Directive? Mika.
Thanks. There will be quite some pain points in this process of getting a compensation if you experience harm from an AI. So I don't know. I think there are 2 points to address. First, the AI liability directive that was already mentioned, but also the AI Act itself. I mean, the AI Act itself, it gives consumers a right to an explanation, a right to information if they are affected by a high-risk AI system. And in principle, in theory, they could use this information to obtain compensation in some form by going to court or doing a complaint with a specific moderation service, but will this really work in practice? I don't think so. First of all, how do you know it's a high-risk AI system if you have been affected by it? There's no labeling obligation for a high-risk AI system. There's no labeling obligation that if you use it, that you that you are entitled to get this information that you could possibly use in calls. And even if there would be, if you would be aware of that, if you would ask the information, you would be given information, it's highly unlikely that the information that you will get provided is sufficient and really good for being used, for example, in court, because the AI is there pretty general in the way he expresses this information rights. So I'm a bit pessimistic here, to be honest. But the first point is there's no labeling obligation, so you probably don't know that you are that you can use this right in the first place. So AI Act is a bit bleak on this issue. Comes in the AIA liability directive. Well, the AIA liability. Let me first say we appreciate that the Commission proposed the AIA liability directive to address the problem of consumers not getting compensation for AI systems. Unfortunately, however, the proposal that we see is not sufficient for ensuring that consumers really get an actual compensation when they are harmed by an AI system. And Peter went already into this, and you think many of the points I could just repeat. But so we hope that after the European election, the Commission will pick up the AI liability directive again, which has now been put on hold until the AI Act is finalized. But if the Commission will do this, we see some problems and that we would like to have addressed in the ongoing process. Problem is fault-based liability, which means consumers have to prove that the provider of an AI system or the deployer of an AI system has done a fault, and then they can get a compensation. And this is practically impossible. How will you do this? If you are a simple consumer, not an AI expert, even they will struggle. But the burden of proof on consumers is so high that it will hardly be able, that it probably will not be able to go to the first step, to this transparency disclosure requirement in Article 3 in the AI liability directive. This will be the first hurdle. If they can do this, they will have a second, then they have to prove the fault. And I simply don't see it. And so there are some things that the Commission should address. The first is the labeling obligation. Consumers should be made aware that they are confronted with a high-risk AI system or with an AI system even in the first place. The disclosure requirement, it should be changed into a more concrete and specific right for information that is easier to handle and that consumers can actually work with. And then the whole burden of proof issue, I think it's a misguided concept in the world of AI because it makes no sense. Economically, it makes no sense. If you put the burden of proof, if you have two parties and they're trying to solve a conflict, and you put the burden of proof on the party that has much, much, much higher costs to show that an AI system has been fault. And on the other hand, you have a deployer who has much more insights, who has much more information, much, much lower costs to show that an AI system did not approve. You should simply switch the burden of proof. I mean, it's straight economics. So we have to talk about a strict liability issue, and that would something I would appreciate if the Commission will address this in the future.
Well, again, quite a negative picture, but the good news is that you have provided very concrete recommendations on what can be done, and the good news as well is that the AI liability directive, if it's picked up, can address hopefully some of these issues. Marike, do you also see the picture as negative as Peter and Mika? What can member states and microsurveillance authorities and other competent authorities do, also procedurally speaking, to address and best implement the limited rights that consumers have under the AI Act? How can we ensure that consumers are sufficiently protected? Do you want to comment?
A big question, but I don't have the answer, right? No, but before addressing that, I think it would be good to to have a view on what we in the Netherlands are doing on enforcement. I heard Jan call it a philosophy, you can say that. Because as we all know, the scope of AI is so broad. So if you look at enforcement, how are you going to do that? In the Netherlands, we asked 2 authorities to give us some advice. So we have the advice from out of their practices. So it's the Data Protection Authority and the English term, the Digital Infrastructure Authority, that have put together an advice for us as legislators. And at the moment we are discussing that. What they see as, well, I think it's a problem, that you cannot think that all authorities have sufficient knowledge of AI systems to enforce the AI Act. So what they suggest, and we are still, as I said, we have nothing decided yet, but to only have a few authorities appointed as competent authorities for the AI Act and make sure that they have the sufficient knowledge on AI systems. And they should work together with the sector-specific enforcement authorities. And there can be an exchange of knowledge and also information. And we as legislators may have to make that possible by writing the legal basis for that. But that's what we are discussing at the moment. And I think you can say that the consumer authorities is such a sectoral authority in this regard. So they should work together with one of the competent authorities to enforce the AI Act. And to come back on the consumers, where do they complain? There should be a central contact point. But as a consumer, do I know that my problem is caused by AI? I think most consumers aren't even aware of that. So what will they do? They will just go to their normal contact point, which would be the consumer authority. So I think in that way, the consumer authority looks at the complaints and they can maybe assess if AI is involved or not, or discuss it with the competent authority on AI, and then they have to act on those complaints. So I think in that way, there is a way that consumers can be heard and something can be done about their complaints. Mm-hmm. But as I said, it's still, we are in the process of deciding how to put it in place, and I think we have a lot of work to do. And even then, if we decide on a system or a philosophy, and we have it in place and we're going to enforce, even then we have to see if it works, if something will be needed extra or needs to be adjusted. So I think we still have a lot of work to do in the upcoming years, I think. Yeah, I hope that answers some of your questions.
Thank you very much. Yeah, I think we could organize another panel next year and then the following one and the following one, and still we will have more questions to debate. But now I want to turn to you. You've been very patient and attentive from what I can see from here. And I was wondering whether you have any questions for our panelists before we move the conversation. Yeah, my colleague Federico will take questions.
Hi, thanks. Mike.
I suggest that we take 2 questions and then you can answer. Yeah, thank you.
Yeah, Michael Veal from UCL. I had a question around the product liability, the AI liability director proposal and standards, which Peter mentioned already play an important role in private law in some situations. When you look at the rebuttal of the rebuttable presumption and what it takes to provide it, the Article 4 of the proposal suggests that you use the AI Act criteria in order to trigger that presumption. We know the AI Act criteria are going to be in practice met entirely through private standards, and we also know that the AI Act criteria are very vague, and that many of those things will result in assessments by the deployers or the producers of these systems. And these assessments might look like bias assessments or accuracy assessments, cybersecurity assessments. And standards don't usually lay out sort of just the need to assess something and a methodology for assessment. But that is what the standards are going to do in practice. That's already what the AI Act asks. Mm-hmm. So is there not a disconnect here between the consumer is meant to go and say, the AI system doesn't comply with the requirements, but the requirements are a process. And the process, so how is the consumer supposed to ever say, was this assessment, which is private and I have no access to, carried out in a robust, rigorous an understandable way. How is the authority even meant to do that?
Thank you. Very interesting question. We had another question in the back. Maybe we can collect that, and then the panel can address both questions. I think Asper had one, no? Yeah. Yeah. Thank you.
Hi, John Selby, Proof Corp. Building upon that, what role do you think there will be for insurers in terms of influencing the behaviour by deployers and developers to do appropriate assessments? Because if the insurers will refuse to provide coverage for claims, that may drive a push into the developers and deployers to actually improve their assessments to be able to provide evidence to justify being able to make a claim on those insurance policies.
Very interesting. Yeah, so maybe, Peter, do you want to answer the first question, and then the other panelists can complement, and then we turn into the insurance question?
I'd rather go for the second question because there is no. The first question was not a question. It was a solid statement.
So do you agree with the statement?
Yeah, of course. I mean,
Okay.
how can it possibly be? It can't fly. Actually, I already put down the notion of insurance on my notes here when Jan was talking about what industry will do or how they could safeguard their operations. In particular, when you have a deployer that uses some AI system that someone else has devised and that turns out to be defective in any way. Now, of course, ideally there would be a contract that would contain a redress clause, but that redress clause only makes sense if there are funds at the other end available. To be sure that there are funds available, you will need insurance. Now, I think we know from some areas that insurance companies will be quite cautious. Floodings is one of those recent areas, as we know from Germany, to give insurance coverage for, well, if there is a high risk. So indeed, I would expect that this could be an additional control instance that might at least provide some safeguards to those businesses, to those industry that don't take the risk, that don't want to take the risk, which will only be part of them. But for those, yes, I think insurance can play a significant role.
Co-panelists, do you want to comment? No. Jan, maybe, do you think that the role of insurance is going to influence the behavior of deployers and developers?
I think there's certainly going to be a demand for insurance, but if the insurance companies will be able to come up with something that is actually workable, and as Peter was saying, if they're going to be willing to create these policies, we'll have to see. But I can certainly see the appeal, of course, from the business side for having some insurance. Can I also react to the first question a bit
Please.
as well? So I think I don't have an answer as well, but I think that's also a very, for me, existential question regarding sort of the entire new legislative framework structure that we have and our entire sort of accreditation infrastructure as well. And I think that goes into reflections on maybe if or what should because there are, of course, rumors that there might be a new 2.0 version of the NLF in the next mandate and whatnot. So I think these are some questions that could be thought of. What should that NLF 2.0 potentially look like? Should we be looking at, I don't know, new modules for conformity assessment, perhaps? Because, I mean, standards are basically there for internal controls and whatnot. Is something like AI suitable for internal controls in these contexts? I mean, the AI Act says yes, of course, and I mean, that's very good from a business perspective. But like I said, these are some existential philosophical sort of thoughts for the future.
Very interesting. I see that there are more questions. So unless any of the panelists wants to react to what Jan said, all clear. Thank you.
Thank you. My name is Nena Dragicevic, and I have worked at the Dutch Data Protection Authority, but I've also worked at a company that built customized AI for clients that want to change their processes, be more efficient, be more data-driven. And I was wondering, from your point of view regarding the liability of these type of companies, companies that under the GDPR were traditionally seen as processors, as companies that don't determine the means and the purposes, but the clients who are usually not experts in the AI technologies, the abilities, the risks, etc. And now, of course, under the AI Act, with these new definitions, the roles of provider. So in your point of view, with this new legislation, how does that change the liability for these type of companies?
Any takers? Or maybe we can gather another question, yes. And then you can think already your best answer.
Hi there, Joseph from South Africa. I might be speaking from a point of ignorance because I haven't read the AI Liability Act, but I just want to ask a question in regards to standard enforcement and transparency that was raised. You said that the standards are enforced in the initial creation and development of these AI systems and development, but it's difficult to think how these standards can be continuously applied when you consider that these are self-learning models that are based on consumer utterances and engagement. And the aspect of applying a more learnable or more understandable or explainable aspect of how the AI and systems work could then also create systems in which the AI then don't function properly in the first place. So you enter a situation where either you choose to create systems that may be more redundant in the preference of being more explainable, or then switching liability roles and making it so absolutely impossible to determine for a consumer when things go wrong, based on the aspects of private companies being more incentivized to hide secrets or risks from them. What are your views on that?
Very interesting. Who would like to take either of these questions?
These are the tough ones now.
Yeah. Please, Peter.
I could give the first one a try, although I only partly understood it. First question, you're saying you're making processes more efficient. So the AI you deliver to your customers does not go into products as such. So we're not in the scope of the product liability directive where this could be a part product or something. So we're still outside in the liability nirvana of the AI liability directive or national law of whatever kind. Well, I don't think that you need to fear much as we determined before, as it will be pretty impossible to get the first user liable in the first place, and even less the one standing behind. So with the system that is currently envisaged, I would be pretty confident not to be liable.
And are we switching liability to pick up on the second question? Maybe, Jan, I don't know if you want to comment on that also in relation to the first question. I'm sorry, because I cannot really see you.
Yeah. No worries. I mean, yeah, difficult question. For the first one, I don't really have either an answer. Neither, I think for the second one, if I understood it correctly, is questioning if we need better standards enforcement. I'm sorry, I got lost a bit with the second one.
Maybe if you can repeat.
It's just that what I'm trying to say is that standards are usually applied to these products in the beginning of the implementation. And it's difficult to enforce or difficult to see how the standards will be affected while consumers are using them and while the systems are learning from consumer behavior itself. So in that regard, to understand liability and to enforce it, the systems would thus have to be explainable, but then that would make the systems redundant possibly as well. So you have a battle between whether you create more explainable systems with redundancies to ensure that standards are complied with, or do you switch liability regimes in the hopes that things get better, but also incentivizing more secrecy, more hidden tactics to try and limit liability in that sense?
No, I mean, difficult question. I don't think I have a good answer. For me, though, I think key part will be how has the state of the art developed in the creation of that standard. So is the initial standard flexible enough to be able to take into account how, say, the algorithms are developing and learning, we could say, or not? Switching liability and regimes, and that could also obviously affect that, but I don't know.
Mika, do you think that companies are going to use tricks to kind of hide and away from liability? And do you think standards are too early? Of course, it's speculation, and we hope that all Business Europe's members will behave.
I'm an optimist. I see the glass is half full with poison. So your question about the switching of the liability regime, I mean, I'm not sure if I completely get it, but you say because consumers are simply not able to go through the fault-based liability system, and it will be very difficult to implement it, also because of the transparency requirements, because they implement a system, they follow a standard, and after 2 years, when the standard, after 2 years, the system evolves, or it's also possible that the standard becomes really outdated, this system will not work. So, as I understood you, you are arguing in favor of a strict liability regime where you switch the burden of proof. I mean,
Sorry, I don't know if my voice is loud enough, I apologize. But the concern is that if you, I agree that strict liability is an option, but the concern is that it might create a system whereby companies are more incentivized either to not develop these softwares or to develop them in a more or less transparent mechanism, even with existing standards in the case of liability being directed to them. As you said, high risk aspects or labeling isn't necessarily attributed to any AI system, and it's difficult for a consumer to ever really understand when it's being used. There's also the complaint, and that's why I'm asking about explainability, that a company might also use the aspect saying that it's a self-learning system. We can't be liable for how the system develops based on how you input or how you've taught it to input or understand information. So it might become even more complex for a consumer to get redress in that situation, even if it gets switched over.
I mean, I think that seems Mika is nodding, so yeah, indeed, the picture is not very hopeful for consumers. But Peter, you want to react briefly, because I see there's another question in the back.
Just one attempt. I must confess, I'm just a consumer lawyer. I'm not an AI person. But my understanding is that AI systems do not necessarily need to learn any crap they find outside in the real world, but that you can confine them and limit what they can learn and what they cannot learn. So if you have, if you're missing that sort of limitations in your AI system, allow it to learn from the most stupid people in the world and from the most stupid Telegram channels that you can find, etc. I think that is a defect in itself. But that's, I say, my very limited understanding of the matter.
You're very humble. Please, Gloria.
Hello, Gloria González Fuster. I had a question to come back to Article 85 of the function. Hello, of the AI Act. Maybe I missed this because I was late. But when I read this, I think you have to be optimistic, very, very much, to think it will work. Because I read everybody has this may lodge a complaint. And then the authorities may or have to take this into account when they do something unrelated, but there is nothing specific about what do they have to do concretely for you with your complaint. And looking at this from the perspective of the GDPR, where you have this right to lodge complaints, and then they have the obligation to actually do something, at least to pretend they do something with the complaint, but it has been a fight to actually get some clarity on this. Can you really be that optimistic that you may lodge the complaint, but they will not just delete it or throw it to the trash bin immediately? What are the hoops there? Thank you.
Very interesting. Marika or Mika?
Well, I can say something for the authorities. I think at the moment, also the practices in the Netherlands, it is, the authorities not reacting on all complaints because simply they have to prioritize and able to do something. So they will look at how serious the complaint is, how much harm is being inflicted, and so on. So that I think that will be the same process in assessing the complaints that may have a link to an AI system.
Yeah, the Article 85 is interesting because it links to the directs the member states and the national implementation process towards the market surveillance directive, and this regulation, and it says, and there it's laid down that authorities that are in charge for market surveillance, that they have to lay down and specify procedures, also how to handle consumer complaints. It's not very detailed, but it describes a general process that the authorities have to develop proper processes to how to deal with consumer complaints. And I agree, probably not every complaint will be simply able to be to lead to the desired outcome of the consumer simply because there's a big mess. But still, every consumer has the right to complain, and well, there is the rule of law, and everyone should get his rights in the end. So that probably has to be dealt with via this the processes implemented under the market surveillance.
Yeah, thank you. Let's hope that in the national implementation phase, indeed, market surveillance authorities will learn something. Or otherwise, they should come to CPDP to learn what has happened with the GDPR enforcement, or a bit of lack of thereof. Yeah, thank you. To really make it work for consumers. And just to conclude, by all of you, if I may, in 1 minute, no more, can you tell us what would be the most important thing to address to really end on a positive note, like to really make it work? Because, of course, we may like or not the AI Act. Of course, things could have been gone better. I'm sure a lot of people in this room would have lots of recommendations. We heard already a few. But yeah, what's the most important question to resolve in the coming months to make things work so we don't come in the years ahead and say, this is a mess, we need to revise the AI Act? Let's start with John.
Yeah, for me, I think it's sort of already hinted at market surveillance. Is the market surveillance authority, are the people competent for AI? So are the skills there? So that's where the enforcement is going to be happening on the ground in many instances.
Mika?
My advice is to make sure that the national market surveillance and the implementation involves civil society in a meaningful way. And for civil society, my advice is to address the still ongoing processes with the guidelines and the delegated acts.
Right. So let's not underestimate the maybe boring but very important work that lies ahead with secondary legislation and soft law. Indeed, clear. And Marike? Taking notes as usual in this panel.
I do not have an advice, but something that me and my team will work on, and that's, I heard it already, legal certainty, and it also comprises good enforcement. I think that's the only way to make it an effective law.
So the goodwill is there to make it work.
Yep.
Clear advice. Peter?
I guess I'm disciplinarily biased here, and I don't trust in public law enforcement as I'm a private lawyer. So what I would like to see is a robust complementary private law liability system that creates an additional deterrent from establishing AI systems that are unsafe and cause harm.
So thank you very much. I mean, we heard that the AI Act was approved by member states yesterday. The work is not done, far from it. I hope that's a clear message from this panel. The good news is that you are experts on this, and many others will help feed the process to ensure everything works. So see you next year probably to discuss this further. Please join me in a round of applause for the wonderful panel we had. Thank you.